I'm turning to Ronald Hargrove.
Jonathan Baber on behalf of Mr. Hargrove.
All right. Is Mr. Hargrove here?
I do see a Ronald Hargrove name. There we go,
Okay.
Judge.
I think I just heard him. He's coming on. All right. Okay,
Thank you, Your
Mr.
Honor.
Hargrove. Go ahead, Mr. Baber.
Yeah, today is the date and time set for a couple of things. It's a status conference, Judge, but it's also a hearing date for my motion to withdraw. I'm really just going to rest on what I put in my written motion for this court. I really can't disclose too much more in regard to what the conflict is between me and my client without risking attorney-client privilege, and I don't want to waive that on behalf of Mr. Hargrove. But I do believe there's been a breakdown in the communication between me and my client. We just aren't seeing eye to eye on certain aspects, and I want to respect his wishes on how he wants to have his case represented. So therefore, I'm asking this court to consider withdrawing me from the case.
All right. Mr. Hargrove, well, first of all, Mr. Baber, you are appointed to represent him. Is that correct?
I am.
I do see that in your motion. Okay, give me just a second to...
And I want to stress to the court, too, that Mr. Hargrove has been very respectful. It's just a situation where we just do not see eye to eye on certain things.
All right. So, Mr. Hargrove, you understand what, without getting into details, because I've read the affidavit of Mr. Baber, but do you understand what he is saying?
Mm-hmm. Yes, sir.
All right. Now, if I allow him to withdraw, which is what I'm leaning towards right now, I'm not sure whether there will be another attorney appointed for you or not. I don't know.
No, I was just confused about a bunch of things.
Right. But, you know, when there's a significant disagreement as to how to proceed, an attorney cannot go ahead and present something to the court that the attorney believes is not justified by law or fact, even if his client thinks it is. So he can't do that if he believes, that's against the rules that we have to practice under.
Okay. Well, let me ask you a question.
But you can ask it, I'll answer it if I can.
Are you the trustee for the Cesta KV account, Ronald Gene Hargrove II, or any account thereof?
Are you asking me that question? I have no idea what you're talking about.
Welcome back, everyone. Buckle up, because today's courtroom drama gives us everything. A fed-up judge, a withdrawing defense attorney, and a defendant who is absolutely convinced he has unlocked secret legal theories most lawyers apparently don't want you to know about. We open with a hearing that should have been routine, a simple status conference, but quickly spirals into a clash over trust, representation, and a concept sovereign citizens love to bring up: mysterious trust accounts supposedly attached to your name. Meanwhile, the defense attorney wants out, says the communication has completely broken down, and you can already feel the judge's patience thinning as he tries to keep this hearing grounded in reality. As we move through today's video, watch closely for the subtle turning points, when the judge stops indulging nonsense, when the defendant doubles down instead of backing off, and when the courtroom shifts from legal procedure into pure theater. We'll also see how judges handle sovereign arguments without escalating the situation, and how defendants sometimes end up hurting their own cases more than anything the prosecution could ever do. Stay with us, because the tension only builds from...
You don't know
I
what I'm
suspect the answer is no, but we're really not going to go down that road. Right now, the only question is whether or not Mr. Baber should be your attorney or not. He's filed a motion to withdraw, saying that he can't, basically you have a disagreement on how to proceed. That's too significant for him to proceed.
Okay.
All right, so I'm going to allow him, Mr. Baber, was there an order that accompanied your motion?
No, Judge, I will prepare one and present it to the court by tomorrow.
All right, that's fine. I'll go ahead and sign that. Mr. Hargrove,
Yes, sir.
You wish to have another court-appointed attorney?
No,
Or do you want to represent yourself or hire your own attorney?
Well, I guess I'm not gonna get anywhere. No, my questions aren't being answered. So I don't know what to do.
Well, I need an answer. If you want to request another attorney, I can have you interviewed again by MIDC. They may or may not appoint an attorney for you or allow one. What do you want to do?
Well, a witness and some other things.
Okay.
I guess I need an attorney.
What you're seeing here is something judges encounter more often than you might think. When a defense attorney asks to withdraw, it usually isn't because of one small disagreement. It's because communication has collapsed in a way that makes ethical representation impossible. An attorney can't just walk into court and argue whatever the client demands, especially if those demands involve legally baseless strategies or conspiracy-style theories. Notice how carefully the lawyer avoids specifics. That's attorney-client privilege at work. He can't air the details, even if they would make his request look stronger. The respectful tone from both sides tells you something important. This isn't personal. It's about practicality. When a client refuses sound legal advice, pushes fringe arguments, or insists on tactics not grounded in law, withdrawal becomes almost...
Well, I mean, it's up to you. I'm not necessarily going to appoint one for you. Ms. Parker, is Mr. Brown there?
Yes.
He has. He just popped on. Mr. Brown, this is a bit of a new one on me. I don't know if you heard it all. Mr. Baber was appointed to represent Mr. Hargrove. He withdrew because they had some disagreement on what should be presented to the court. And I've allowed the withdrawal. Mr. Hargrove still wants a court-appointed attorney. Does that have to go to Mr. Slough, or is he simply re-interviewed by you?
I don't necessarily know if he even needs to be re-interviewed unless things had significantly changed, as he did have a court-appointed attorney. So unless things have significantly changed, I don't think a withdrawal would require a re-interview. I think he would just have to be appointed another attorney.
All right, so we'll notify Mr. Gilo's office of that. Mr. Hargrove, that attorney would be appointed for you. You'll be given the name and number of that attorney. You should give them a call. Pam, if you call, or that attorney would you also let them know they may want to call Mr. Baker.
I'll try to remember.
Yeah, okay, I get it completely. But Mr. Hargrove, I suspect that if this attorney has the same situation that Mr. Baber does, you may end up representing yourself or having to hire your own attorney.
Well,
okay.
I wish you would just please answer my question.
Well, that's nothing that I can answer in a situation like this. The only question, you need an attorney, you've requested an attorney. If the next time you come to court, I won't be here because there'll be another judge. As my term ends at the end of this month, in about 10 days or so, 12 days. So any argument would be presented to them, but it has to be done according to the court rules that we're all bound by.
So you don't have to answer my question?
Key teaching moment from the judge. He reminds the defendant and everyone watching that lawyers are not hired guns who simply present whatever narrative the client provides. They are officers of the court, bound by ethical rules. If a client demands filings or arguments that have no basis in law or fact, the attorney is required to refuse. Otherwise, they risk sanctions, discipline, or even losing their license. So when you hear, "We just don't see eye to eye," that's often code for something bigger. The client wants to go down a road paved with pseudo-legal theories, and the attorney isn't willing to follow. The judge is signaling the same thing. Disagreement is one thing, but insisting on legally unsupportable positions is another story.
24-43189-ST. I see you, Mr. Hargrove, on Zoom. You represented by counsel, Mr. Hargrove?
I represent Mr. Hargrove, Judge.
All right, thank you.
what we're going to ask the court to do is accept the plea to count one with the second offense dismissed.
Mr. Fortier, is that an accurate statement of the agreement?
I don't know yet, Your Honor. I can't find the case for some reason.
All right, I'll give you a second.
Mr. Gilo, did Miss Brooker email you that offer?
Yes, on the 9th.
Okay. Then, yeah, Judge, that would be what we're gonna do then.
All right. Mr. Hargrove, you've heard the attorneys talk that there is an agreement being offered to you that if you plead guilty to the first offense of operating with your license suspended, the notice for second offense, which enhances the penalty, would be dismissed. Is that what you want to do? You're on mute now, Mr. Hargrove. You're going to have to take your, there you go. Is that what you want to do today? I'm sorry.
I just had a few questions.
Well, you're going to need to talk to your attorney about those questions. Do you need some time to do that?
He can't answer them for me.
All right. Well, then what are your questions? Let me see if I can answer them for you.
Okay, well, I don't understand how you can be the trustee of my SESTA KB account, Ronald Gene Hargrove II, and not have my best interest.
I'm sorry. What? I don't understand what your question is.
How can you be the trustee of the SESTA KB account, Ronald Gene Hargrove II, and not have my best interest?
What is that account that you're referring to?
Oh, God. The SESTA
Yes,
KB
it
account
is, but
that everybody,
Go ahead.
most people have, and you're the trustee. Just like the Secretary of State is trustee of it. You are my trustee, aren't you?
And there it is, the question that instantly tells the court exactly what kind of argument is coming. When a defendant starts asking whether the judge is the trustee of some secret account tied to their name, we've entered sovereign citizen territory. These theories usually revolve around the idea that a hidden financial account exists under your legal name and that court officials somehow control or profit from it. Judges hear this and immediately know what they are dealing with. Notice the judge's reaction, total confusion, followed by firm redirection back to the real issue, which is counsel representation. That's deliberate. Courts do not legitimize these concepts by debating them. They shut the door, stay focused on procedure, and move on.
Not that I'm aware of.
Uh-oh.
Why would I be your trustee? Mr. Gila, do you have some additional information that I'm not picking up on?
No, Judge.
It's just something that I believe in, and I've seen evidence of, and
What leads you, Mr. Hargrove? What leads you to believe that I'm your trustee?
because of a former case I've seen.
A former case. What former case are you referring to?
In Roscom, and a friend of mine asked the judge that, and he couldn't answer him. So
That's probably because it's not factually true. What information do you have that leads you to believe that I'm a trustee for you?
In that case, the judge quit 6 months into his new term because he was dishonored, and the sheriff. So,
Mr. Hargrove, the question was not about a Roscommon County case. It was about this particular case. You've alleged that I'm your trustee. I'm asking what information or proof that you have that is true.
so you're just denying it?
I don't know of any information that it makes it true.
Okay. If it was
What information do you have?
If it was a misdemeanor,
Go ahead.
If it was a misdemeanor, would it be true?
No. Misdemeanors and trusts have nothing to do with each other.
Okay, well,
there has to be some court order for me to be a trustee for you. For anybody to be a trustee, there has to be a court order. Do you have such a court order?
no. I just believe that you are my trustee of the SESTA KB account. Ronald Gene Hargrove II, and that's.
Could you speak a little more clearly and tell me what that account is?
I'm not sure. I just believe that you are my trustee, and if you deny it, then you deny it. Okay, we'll move on from there. I guess. And another thing is, I paid $1,000 for a reinstatement fee, but you guys keep saying I don't have a license. And where did my $1,000 go? I don't understand this.
Who did you pay $1,000 to, Mr. Hargrove?
The Secretary of State or the
Then you need to ask the Secretary of State.
Well, I believe I have my license, and they just keep. There's a screw up somewhere.
Then you need to contact the Secretary of State. But I'm not connected to the Secretary of State. I'm the court system. I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Well, knowing that I think I had a license at the time, doesn't that change things?
It would change things only if it were true, and I don't know that it's true. Just because you believe it doesn't make it true.
Yeah.
This breakdown is spot on. Sovereign citizen ideology often relies on redefining everyday legal terms into something mystical or financial. Words like trust, account, or estate get twisted into evidence of a giant secret system. But when those ideas meet actual law, they collapse immediately. Courts don't recognize imaginary trusts created out of thin air, and judges certainly don't become trustees by presiding over a case. What's important here is consequence. Every minute a defendant spends chasing these myths is a minute they could have invested in a real defense. Jurors don't buy it. Judges don't buy it. Appellate courts definitely don't buy it. In the end, the only person hurt by these arguments is the defendant making them.
All right, Mr. Hargrove, your attorney has told me, and the prosecutor has agreed, that there is an offer on the table for you to plead guilty to operating with license suspended in exchange for dismissal of the second offense notice, which makes this a much more serious charge.
Okay.
Do you want to accept that today, or do you want to have some additional time to speak with your attorney?
No, they don't have nothing to say to me. Their best interest is of the court. So I'll take that, and I would hope to get the same fine everybody else did today. Thank you very much.
Well, I can't guarantee that because you're in a different circumstance than everybody else.
Well, I'm pleading guilty to the same offense they just pled guilty to.
But your background is not the same as theirs.
You know what? I'll plead insanity.
You can hear the frustration simmering now. The judge is trying, patiently, to steer the defendant toward the safest path, competent legal representation. Courts actually prefer when defendants have attorneys because it keeps the process orderly and protects constitutional rights. But every time this defendant resists, hesitates, or insists on arguments pulled from sovereign playbooks, he narrows his own options. Representing yourself may feel empowering in theory, yet in reality it means going toe-to-toe with trained prosecutors while also navigating evidence rules, deadlines, objections, and procedure. Very few people can do that successfully, and almost none of them learned law through internet conspiracy forums. The judge's warning here isn't sarcasm, it's a lifeline.
What's your name?
Oh, you were up for an arraignment this morning.
Yeah,
that was at 8:30.
Yeah, I dropped my son off at 8:30. I didn't know because the court didn't open.
Okay, so what we have to do,
I'm trying to figure out how to get it.
Well, I don't think you're going to.
You're
not going to. I don't think you're going to. Are you going to have time to address that? You want to go through an arraignment?
Please, that's fine. Thank you.
Then you go discuss it with Mr. Sierra.
We talked already.
What's that?
We talked already.
You already talked? All right, well, let me finish.
Form's already submitted.
Okay, let me take care of these here quick and I'll get right to you. Let's go to the record in the matter of the People State of Michigan versus Brown, file 2-44177FY. And state your name, sir.
Quentin Brown.
Assistant Public Defender Dario Sierra appearing on behalf of Mr. Brown for the purpose of arraignment.
Very good.
We have reviewed that felony file. I waive reading at this time. I'm speaking with him. He had asked it a set for the probable cause conference in the prelim. After he has just advised now that he would like to self-represent. So court-appointed attorney is being denied by Mr. Brown.
Well, it's not being denied. He
He was
just
previously
declining to
granted,
accept it.
so I-
All right. You sure about that? You want to represent yourself when someone goes to school for many years to learn how?
I know what's going on better than anyone that can, because it's not right.